Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. Not all nurses save lives. Some, for example, you can find sitting around with their feet propped up on the desk at nursing homes and, of course, doing very little for the patients they're supposed to take care of. Someday you'll need to ask me about nursing homes. We call these nurses who are not fit to work for doctors or hospitals failure nurses. In the legal profession, there are failure lawyers as well. And I think one of the worst of these failure lawyers is not that snarky plaintiff's guy you see on television saying, "Hey, have you been hit by a meteor? It might be somebody else's fault. You probably have a claim." It's not that guy. And it's not the guy who plasters his picture all over every billboard in the state of Alabama with billboards saying, "Call me." These guys are annoying, but generally speaking, they do good work for their clients. The same would apply with the lawyers in the larger firms in downtown areas like Atlanta, St. Louis, Chicago, places like that. Big firms hire good lawyers and they tend to pay them well, and they are usually very good lawyers. They're not failure lawyers. But we in the legal profession, we also have failure lawyers. When they can't make it in any other branch of the law, they wind up doing debt collection law. Debt collection, which is generally the unprincipled harassment of widows and orphans, and also a few deadbeats, is law that doesn't really require much understanding of the law. It just requires a law license. I've proved this a number of times in court. They are so used to winning by default that they fail to master the key skills, evidentiary skills particularly, like foundation, evidence, hearsay, that sort of thing. The way debt collection lawyers get employed is they get hired by collection agencies. Like your average plaintiff lawyer, for the most part, they work on a contingent fee basis. Most of the time, that contingent fee is around 20 to 30%. And these lawyers are actually employed by the collection agency themselves. And then they hire other lawyers to sue on their behalf. Now, in most states, there are two levels of court. There are magistrate and associate court levels where where the maximum judgment can be like between $25,000 to $50,000. And then there's the circuit court or district court where the full amount of any debt is potentially collectible. Most people meet debt collection lawyers when they run into trouble with their credit cards, and usually it's not a huge amount that the debt collector's after, usually somewhere between $5,000 and $25,000. Again, depending on how badly people have put their credit card on the critical list. They get into trouble with their credit cards because they buy more things than they can pay for, and something bad happens to them. Maybe they lose their job. Maybe their kid breaks their leg and needs to have their leg fixed by an expensive surgeon. Maybe their car dies. Whatever happens, they find themselves further and further behind on their debt. And one day, a summons arrives with the sheriff attached to it, and he says, "You've been sued and you need to answer this complaint. You need to go see a lawyer and get that done for you." Now, if you don't have money to buy gas, if you don't have money to fix your car, if you're having trouble paying for your kid's medication, you are not going to have money to go pay $200 an hour for a lawyer to tell you there's nothing he can do. Because that's, I think, what most lawyers will tell you in that situation. Most of them will recommend that you go on to file for bankruptcy. But now, let me explain how it is that debt collection lawyers can be so successful. Because they are. They get judgments and they get lots of them. And the reason they get these judgments and lots of them is because most of the time people don't contest the debt. Sometimes a person who has a problem of this nature, as I said, will consult with a lawyer, and the lawyer says, "Hey, you need to go see a bankruptcy lawyer. Here's my friend Milt, go see him." When they do that, the collection agency, collection attorney, simply takes his place in line in the bankruptcy proceeding and gets whatever the bankruptcy court gets him. But most of the time, people just do nothing. It's essentially, I'm going to put my head in the sand kind of approach. And I'm going to hope that these bad people who are harassing me will go away and leave me alone. That usually does not work. Doing nothing is not a good strategy. Many times these folks will show up in court and they'll tell the judge they don't have any defense. Now, that may or that may not be true, but in many cases it's not true. There are statutes of limitation. There are problems with verification of documents. There are things that can cause the debt collection lawsuit to fail. But if you don't know what they are, and a lot of this law is somewhat esoteric, well, then you winding up having to pay the entire debt. I worked for many years for the good people at the Samaritan Center in Jefferson City, Missouri. They had a legal plan, and the legal deal was that we would represent people who were indigent in things like debt collection matters. And my favorite clients were the ones who were sued by what I would call the third tier debt collectors. Here's how you become a third tier debt collector: you buy debt that other people have not collected. So when someone owes money to a gas company credit card, for example, the gas company tries to collect. If it doesn't work, it sends it out to a collection agency. When they send it out to the collection agency, the gas company will write it off their books. In other words, they'll take it as a tax deduction, money that is essentially a casualty loss that undercuts their profits because they couldn't collect the money. So they turn it over to the collection agency, and they do that by assigning it to them. And an assignment is just a contract that basically says, in exchange for good and valuable consideration, we assign the right to collect this debt to XYZ Collection Company. And now the collection company has a way to go after and get this debt collected. And after the first collection agency can't get the job done, then they sell it to one of these third tier debt collectors. So if you have a $1,500 debt, when it gets sold to the third tier debt collector, they probably buy it for somewhere between $50 and $150. And they earn the right in that situation to collect the debt. And of course, the people who have sold this debt once or twice or sometimes three times before, well, they've already been made as whole as they're going to be made. They don't care what happens. The gas company doesn't care because guess what? They've already written this off their books and taken the tax deduction. So the only people who benefit in that situation are the third tier debt collectors. But because they're cheap people, they often hire really inexperienced or really bad lawyers to prosecute these actions. Now, one of the reasons that they wind up with these third tier debt collectors is that people move. If they can't pay for their gas, they probably can't pay for their house. They've often been evicted. If they've been renters, they've been evicted. They're probably living in their car. They may be very difficult to track down. But eventually, many of these people get back up on their feet again. And so often these debt collection companies will wait 2, 3, sometimes 4 years to go after somebody. By the time they are getting their feet back on the ground and putting money in the bank, that's when these third tier debt collectors show up with their hands out. And of course, one hand is out to collect the money, and in the other hand, they have a crowbar to beat them over the head, so to speak. It's a figurative crowbar. So that's how that whole process works. And so they have law firms in pretty much all decent sized cities, and they call those law firms up and they send them out to sue to get this money. But here is the dirty little secret that they are not going to share with you. That is, while they may very well have an assignment document that gives them the right to proceed against you, they likely don't have all the things that they need to actually succeed in a lawsuit against you. Usually, when you take out a credit card, you sign a credit application. If it's now at a third party debt collection, they don't have that application. You know what they have? They have a statement of account. And that statement of account is what they try to collect upon. Usually, they do not have the actual document that you signed. Several years ago, I represented a gentleman who'd been sued by one of these worst third tier debt collectors, and they wanted $6,300 for a debt that had originally been about $1,500. And that's because the original creditor charged a default interest rate of 24% on the uncollected balance. So over the course of about 2 years, the debt had spiraled to $6,300. The gentleman was a Marine Corps veteran of Vietnam. He had lost his job. He was getting Social Security and he had slight VA entitlements. He didn't have the money to pay the debt, and he didn't have any property or even a car that they could have taken and sold. But they came after him anyway, and that just really ticked me off. So I entered my appearance in that case and I filed discovery asking for the original credit application signed by my client. The other side objected and said, we shouldn't have to prove that. We've got his signatures on some of the documents. Well, they didn't actually have any of the charge slips, but they said, well, we have other indicia that these were legitimate charges, but they didn't have anything with a signature on them. The only signature that they had on any of the documents were from the people who basically gave him credit. They didn't have anything with his signature on it. So I went to the judge and I said, look, they don't have a right to collect this because they can't prove there was ever a contract. Absent a contract that was assigned, this assignment means nothing. There's no way for them to proceed against my client. So the judge ordered them to produce all the information they had on his file, and that really set them off. They came back a week later and asked him to reconsider, and the judge said no. Well, they explained that the assignment agreement was confidential and proprietary, and that it contained trade secrets, and that if it was turned over to a lawyer like me, it would spread all over the internet. And the judge said, okay, I will grant you a protective order that prevents the lawyer from disclosing it to anyone, even his client. But you got to turn it over to him because that's the way the world works. So they turned over the document, and sure enough, there were statements in there like, we can't vouch for the legitimacy of this debt. We aren't going to help you by providing people to testify. Anything that you get is what you get. I don't recall the exact language in there, but basically, when they were assigning this debt, they were like washing their hands of it. They didn't want anything further to do with it. And so, as a result, the third party debt collector was sort of out of luck. In other words, the contract of assignment that allowed them to collect the debt basically told them that it was up to them to get their money. And to make a long story short, they never had a copy of my client signing anything, so they changed tactics. They said, Judge, he never signed anything because he got one of these offers in the mail where they sent him a credit card and they said, if you use the card, you agree to the terms. But they could never show me anything where he had actually gotten it. They had no record of him receiving it. They said, well, we mailed it. And so I said, that's fine, but you got to prove that you mailed it. And of course, they couldn't do it because that stuff gets sent out by bulk mail. So to make a long story short, after about 6 to 8 weeks of arguing this every week or so in front of the judge had had enough and he dismissed the action with prejudice. Now, did my client owe the money? I'm sure he did, but he didn't have a way to pay it. And it wasn't really his fault. He would have been happy to pay it if he'd had the money. But their pursuit of him was just mean-spirited. And in addition to that, they didn't keep any records that they needed to keep in order to prosecute the action. They couldn't prove their claim. And I don't care who you are, if you can't prove your claim, then you shouldn't be in court. While it may seem somewhat wrong for me to have defeated them on procedural matters, that's what lawyers get paid to do. That's what the other lawyers on the other side got paid to do. And I'm sure that the lawyers on the other side more than made up for the loss in that case with all the widows and orphans that they sued and recovered against. Because a lot of times, widows and orphans simply don't go and defend against the debt. This is important. If you do not go to court and defend against the debt, the creditor gets a default judgment. And even if the claim was barred, as many times they are, by the statute of limitations, or because you were not responsible for the debt in the first place, you've still lost, and you'll wind up paying the debt. Once you lose by default, the creditor will either seize your assets, like cars, trucks, bank accounts, or they'll garnish your wages. And if they garnish your wages, that job that got you back on your feet, well, it's going to be gone because you'll be fired because you were garnished. Many employers do this. So go to court, ask for time to get a lawyer, and find help either at legal aid or at a university law school student lawyer program. There are resources available out there to help you if you have a debt collection issue. Now, I don't want to completely skew this. I do know one very good debt collection lawyer. He's in St. Louis. His firm is a very good firm with respect to uh, debt collection law. They're well regarded in St. Louis. He is a nice guy. We had a good relationship. He sued one of my clients, and we were able to reach a reasonable settlement. He moved a little bit. My client paid a little more than he wanted. He took a little less than he wanted, and we settled it. And I think the judge was very happy that we did, because it would have been a really interesting trial otherwise. He was willing to give my client and work with him, and I thought that was really great. And it worked to everybody's advantage. But if you try that with some of these hardcore debt collection attorneys that work for these third-party places, you'll often find they not only have no moral compass, they have no willingness whatsoever to negotiate. Now, there are a few times when you want a no-nonsense, hard-charging lawyer. When you're defending against a debt collector, that's one of the times when you want somebody who doesn't take any baloney from anybody else. Now, as I've just shown you, not all debt collectors are bad, and you shouldn't assume that they are. Some are very nice. A lot of times you can work with them. A lot of times they don't even have to sue you. You can work with them, they'll put you on a payment schedule, and everything will work out. But that's not all of them for sure. And if you wind up getting sued by somebody that you have never dealt with before in your life, that's probably a third-party debt collector, and you need a good lawyer to help you with that. One of the things on my law license says that I will practice law with consideration for the defenseless and oppressed. When you have a 28-year-old mother with two small children who can barely make ends meet, and you're threatening to take away 50% of her paycheck, you know, over the course of the next year and a half in order to pay a debt that her ex-husband, who's now out of the country, ran up, um, that's not that's somebody who is defenseless and oppressed. And I have been very pleased and very honored to have had the opportunity to represent those people. So that's sort of the 411 on debt collection law. It is not something you should attempt to do yourself because you have way too much wrapped up in it, but you should get yourself a good lawyer who does this for a living, and they can help you. And most of the time, even if they can't beat the other side, they can often get you a much better settlement than you could yourself. So that's what I have for you today. Thank you very much for watching. If you have any comments, drop them in the comments down below. Like, share, subscribe, all that stuff we always ask you to do. And if you do have the opportunity, take a moment today and do something nice for someone. You know, I have been blessed to be able to help these people who really had no friend whatsoever with regard to these debt collection lawsuits. And so talking about it here today, that's one of my best memories of being a lawyer. And so I offer that to you, doing kindnesses for people when you expect to get absolutely nothing out of it, and none of those folks ever paid me a dime, nor would I have accepted it. But what I got in terms of payment was a really good feeling inside. So I offer that to you. Thank you so much for being here. Come on back tomorrow. Join me down here at the beach and we'll talk about something else. Hey, as I said at the beginning, none of what I said is legal advice. But let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.